do. Yes, thank you, Raluca, for the introduction. I'm very pleased to be here, and as you said, I've been invited to tell something here about the freedom of expression of judges, and under Article 10 of the European Convention on Human Rights. As far as I'm concerned, that's a very interesting subject, and it also has my personal interest. I wrote a PhD in the past concerning this subject. I have about 20 minutes for this presentation, which is very, very short because this subject is so extensive and there is so much to tell about it. But I will try what I can do in those 20 minutes. What I will try to do is to give you some kind of overall view of the meaning of Article 10 for judges. I will guide you along a systematics of Article 10, paragraph 1 and 2. I will try to include some recent developments because this body of case law is developing rapidly in a very interesting way. And I will also pay some attention to the role of the European Court in this body of case law. And when I'm talking about the case law, we're talking about cases that originate from complaints from judges about negative consequences they have met on the part of the authorities as a result of their expressing an opinion. And this consequence may have the shape of a disciplinary sanction, but it may also be a more covert reaction. For instance, a disciplinary sanction for other reasons, but in reality relating to the opinion, or perhaps a reaction which is presented as neutral, but which is secretly also related to the opinion. So various variations occur in this case law. What we can see is when we look at Article 10, can only explain this to a very limited degree. We see Article 10 and we see a very broad protection. Article 1 has a Article 10, paragraph 1 has a very broad scope. It's standard case law that this article protects not only opinions that are favorable, but also those that shock, offend, and disturb. And the second paragraph defines the conditions that need to be met in order for restrictions with this freedom to be legitimate. European Court attaches a specific importance to judicial speech. European Court sees a link between judicial speech and the independence of judges. So a link between judicial speech and the rule of law. And this is why the European Court has considered this, what is now on the sheet in various cases, that the suppression, the oppression of judicial speech calls for close scrutiny on the part of the court. So it has a very special meaning, judicial speech. When we look at the Article 10, paragraph 1, we can say that judges are met at, well, in this stage of the assessment of Article 10 with a generous European Court. The judge is seen always in these cases as a civil servant. And on the one hand, the status of civil servant doesn't imply much freedom, but on the other hand, for the judge, it opens the doorway to the protection of the European Convention and to the protection of Article 10. This is not self-evident because the judge could also be seen as a state organ, and a state organ is not entitled to the protection of Article 10. When looking at Article 10, paragraph 1, an important question needs to be asked, and that is what is complaining about, what the judge complains about, is that a matter of freedom of opinion or not? We know various cases of judges who present a complaint as an Article 10 situation, but which is not followed by the European Court. And these, I've mentioned two examples of cases on the sheet in which European Court says, no, this is not at the core, at the essence, a freedom of speech that is at stake, but this is a matter of, well, what it calls in this very long sentence on the sheet, appraisal of professional qualifications and personal qualities in the context of his activities, etc. So this is a matter of judges who complain about a reaction, but a reaction is really based on their professional inability or unsuitability for office. And we have seen various cases recently in which the European Court had explicitly to investigate what was the reason for the measure. An important case, a groundbreaking case in this case law is the case Baka versus Hungary, perhaps known to you. I don't know, but this case, well, it revolves around the Hungarian Supreme Court President Baka, who had been appointed for 6 years, but whose appointment was prematurely ended. And a dispute arose between Baka and Hungary in front of the European Court what the real reason was for the premature ending of the mandate. Baka said, well, I've lost my office because I've been critical about legislation, critical about the authorities. And he had uttered that criticism as part of his job. Part of his high office was to present a view on legislative bills in Parliament on behalf of the entire judiciary in Hungary. He had been very critical. The Hungarian authorities, on the other hand, they denied that the ending of his function had anything to do with this criticism. They presented it as a neutral situation, a reorganization of the courts, which involved the ending of this function. And the European Court does not agree with the Hungarian authorities, and it's fines for Baka and fines a violation, and of course that is rather a far-reaching decision, because that also implies foul play on the part of the Hungarian authorities. Groundbreaking case, very interesting. If you want to know more about the framework that is applied in Article 10, you really have to read this verdict, because it has beautifully written out the framework that is applicable. Also, a recent interesting case, Kovesic versus Romania, where also was the European Court had to decide what really was going on, because here too a high public prosecutor was dismissed, and it was denied by the authorities that it had anything to do with her criticism. But here too the court found a violation. It is not always easy to say whether this situation is happening or not, because someone might also turn out to be professionally lacking or unsuitable for office because of the opinions he voices. We can see that in the case Simic versus Bosnia-Herzegovina, which is brought outside the ambit of Article 10. So the question whether it's an Article 10 case or not is not always so evident. It's not always easy to answer. But when that hurdle has been taken, you enter into the domain of Article 10, paragraph 2. And Article 10, paragraph 2 has three conditions that need to be met in order for restrictions to be legitimate. First, the measure, for instance, a disciplinary dismissal, must be prescribed by law. Secondly, it must serve one of the interests that is mentioned here in this paragraph. In these cases, usually in maintaining of the authority and impartiality of the judiciary. And finally, thirdly, this measure must also be necessary in a democratic society. And it's this necessity test in which usually the interesting considerations take place, because this is really a matter of weighing all the circumstances of the case against each other. And the European Court has said there needs to be a fair balance between those interests that argue in favor of the exercise of freedom of expression, and those interests that argue against the free exercise of expression. And this balancing exercise may become rather complicated, as we can see here on the sheet. It's a balancing exercise with all the factors that are put in the weighing scales. This exercise has also been described as a cocktail, a cocktail of ingredients. And if you take away one ingredient, you have a cocktail, you take away the lemon or the alcohol, the entire taste may change. So the outcome may become quite different if you take away one of these factors. What we can say is that there are a number of very important factors. One of them, I've here connected it to the 1 kilo weight, is the expression of the opinion, can that be seen as part of a public debate? If that is the case, the opinion receives a great deal of protection. And especially, and that's what we see in the cases Baker and Covesi, if these opinions are also supportive of the rule of law. This weighing exercise, difficult enough as it is, takes place against a number of principles. Principles which show the tension between, on the one hand, the restraint that is asked of judges, and the other hand, openness that is in the benefit of society or of the public debate. We can see here that public officials should, in principle, show restraint when the authority and impartiality of the judiciary are likely to be called into question. And when thinking about this is quite a broad consideration, because judges, being representatives of the judiciary or the rule of law or other bigger entities, their behavior reflects on this bigger entity. A sub-rule of this restraint, and this is a very strict principle, is that judges need to exercise maximum discretion with regard to the cases with which they deal. So these restraint and this maximum discretion argue in favor of little weight for freedom of expression, but they compete with this principle of the public debate, important issues that are presented by the judge or whistleblowing. This is all, and in the debate about the justice system is seen as a question of public interest. So judges talking about the judiciary, in principle, receive protection and a great deal of protection, of course, depending also on the other factors, such as the tone they use, the words they use, the motives. Is it a fair comment, or are there personal grievances that play a role? What are the consequences, of course, of the expression? Is it damaging to the authorities, to the judiciary, or to persons? The effect of the opinions and of the interference with the opinions on society, the chilling effect, also a very important one. I must say this weighing exercise has become so complicated over the years that it's sometimes very difficult to predict the outcome of a case. It's become very nuanced, but also unpredictable. When we look at the case law, and we include some of the latest developments, then we can say that we see a European court which is very active. Two examples which illustrate this active attitude. In the case Baker, for instance, Article 10 is used to protect statements that have been made by Baker in the performance of his duties, in the performance of his function. Baker criticized parliamentary bills on the basis of his legal duty. And we also see other cases, especially the case Brisk versus Romania, which is also the case. These cases have very interesting dissenting opinions. When we look at the case Baca, we see especially Judge Wojciech, who labels this type of speech in Baca as official speech versus private speech. And he says only this private speech is protected as a human right. So it's far from self-evident that Article 10 encloses and protects the expression of views, of professional views, which are really part of a job description. It's really a very generous approach. What we also see is what I call the unnecessary necessity test. The unnecessary necessity test, I explained that the three conditions of the second paragraph are always used in a fixed order. And this is logical because if we cannot find a legitimate aim, and the second condition, if the second condition is not present, there can be no necessity either, because what is this measure, this dismissal or warning, what is this necessary for? Is it necessary to reach an illegitimate aim? So this is a strange forced exercise which is carried out by the European courts in the case Baca and also in the case Kovesi. And both of these cases, the European court briefly, summarizingly said, these measures do not serve any sensible goal at all, do not serve the rule of law at all. On the contrary, they defeat the rule of law. With that, the cases could have ended. With that, a violation was there. But nevertheless, European Court continues with this necessity test. I can only understand that in the need of the European Court to make its opinion known also on these aspects of the case. And what I can see is that the European Court with this is showing itself a very active court, not a strict rule applier, but a court that wants to put its stamp on European developments concerning the rule of law. It focuses on the spirit of the convention, brings judicial duties within the ambit of Article 10. It's a very purposive interpretation, as the Israeli former Supreme Court Judge Aharon Barak would call it. And the purpose is then not so much the protection of the freedom of expression of the judge, but the protection of the rule of law. So European Court takes a very broad role in these matters and it wants to make its message heard fully. I personally am very curious what is happening next, because as said, this case law is developing rapidly. Yesterday, a very interesting Bulgarian case was ruled, which gives even, I think, more and more protection to judicial speech. We can see this on various occasions that the European Court has found the rule of law a very important interest to be protected in this piece of case law. Well, and this is really what I wanted to tell you about the case law. I hope this helps in getting some sort of overview of this very complex subject.